Hi, I'm Tim Murray, Winnemac lawyer, and on today's clip, a very short clip, I want to help you understand the difference between a will and a trust. Excuse me. Everyone's heard the terms will and trust, but not everyone knows the differences between the two. Both are useful estate planning devices that serve different purposes, and both can work together to create an estate plan that works well for you and your family. One main difference between a will and a trust is that a will goes into effect only after you die, while a trust takes effect just as soon as you create it. A will is a document that directs who will receive your property at your death, and it appoints a legal representative called a personal representative to carry out your wishes and your instructions. By contrast, a trust can be used to begin distributing property at your death, before your death, and after your death. A trust is going to be a legal arrangement through which a person, an institution like a bank or maybe even a law firm, they're going to be called the trustee, or they're the manager of the trust, and they hold title to the trust property for another person called a beneficiary. A trust usually has two types of beneficiaries: one set that receives income from the trust during their lifetime, and another set that receives whatever's left over after the first set of beneficiaries dies. They're the residuary beneficiaries. A will covers any property that is only in your name when you die. It doesn't cover property held jointly with someone else or that's been transferred and held by a trust. A trust, on the other hand, covers only property that's been transferred into the trust. This is one of the biggest mistakes that people make when they create a trust, is they don't fund it properly and transfer their property and assets into the trust. In order for property to be included in a trust, the property has to be put into the trust name. Another difference between a will and a trust is that a will passes through probate. You have to file paperwork with the court and go through the probate process. That means that the court oversees the administration of the will and ensures that the will is valid and that the property gets distributed the way the deceased person wants it to be done. A trust passes outside of probate, so a court doesn't need to oversee the process. Excuse me again. This can save lots of time and lots of money. Unlike a will, which becomes part of the public record, a trust is going to remain private and exclusive to you and your family, or however you put the instructions into place. Wills and trusts each have their advantages and disadvantages. Both of them allow you to name a guardian for children and take care of those kind of things with the family, and they allow you to lay out your funeral arrangements and instructions. But again, a will only goes into effect after you die. A trust, on the other hand, can be used to plan for disability, nursing home care and cost kind of situations, and provide asset protection while you're still living. If you'd be interested in continuing a conversation on how to best use a will and a trust in your estate plan, call Murray Law at 574-946-7819. And because you stayed till the end, instead of being charged a $200 consultation fee, we're only going to charge you $10 to sit down and talk about what your needs are, go through the consultation. Please call Murray Law, 574-946-7819, and make your appointment today. Thank you.